court all the arguments. It's the Special Investigating Unit case versus Moyo and Eskom Pension Fund. The GP09 2022 case. This is a reconsideration of an order that was made earlier. I can confirm then that Ms. Poswa Lerotoli, you appearing for the SIU in this matter.
That's correct, Judge.
And Mr. Odes, you for Ms. Moyo.
Yes, my lord.
Thank you. Can I just make just a few comments? First of all, when counsel is addressing me, all the other people should just put off their microphone to make sure the papers. You should not take me through them. The same applies to the heads of argument. I know that we can be on what's the thing that you guys use in the Gauteng on case lines, but I've got hard copies in front of me. So if you refer me to paragraph numbers, I've got the documents before me. I've got the case lines also, although we're not so used in the Free State to work with that. Please don't traverse all issues. This is a reconsideration application. I'll start with Mr. Odes and he'll argue the matter. Unfortunately, I'm in civil matters in the Free State High Court as well, so I would like to finish by 11 o'clock. I'll allow Mr. Odes 60 minutes, the applicant 60 minutes, and then Mr. Odes 50 minutes to respond in reply. I'll try and keep my mouth shut as all through the time and to allow you to finish your arguments. You don't have to use the 60 minutes, obviously. As I said, you make the pertinent points that you wish to make, and I'll reconsider, obviously. I'll read the papers again. I'll argue, listen to consider the arguments. I'm not going to give a judgment today. Can I just ask Ms. Poswa Lerotoli, what is the idea with this Part B story? I mean, I've been involved in litigation for more than 40 years, 50 years and close to, and the first time that I see you ask for a Part A, where you ask for an order pending Part B, and then pending Part B, pending an action to be instituted. Why do you have this double barrel approach? Is the intention that whatever happens here, that you will go back to a different judge to, on the same papers, ask for the same relief? I mean, normally you get an order, the interim order, that pending the institution of an action, there will be certain relief granted. But here you ask for relief pending Part B, and then B pending an action procedure. What do you intend to do there?
My lord, the practice the practice in this division is that where you seek an urgent application, especially one that is ex parte, you will ask for an interim order pending a full ventilation. Excuse me,
Okay.
Ventilation of the issues.
Okay.
For purposes of
yeah.
Yes.
Yeah.
May I proceed?
Yes,
for
please.
Purposes of yes. For purposes of Part A, the purpose of Part A is just to maintain the status quo until the other party has been heard and has been given an opportunity to respond to its case, and then the issues are properly ventilated. When, for purposes of Part A, it is really in cases of urgency, where an interim interdict is sought, and the interdict will only be confirmed in Part B, that now the funds, as in this position, the pension, the pension may not be paid out until the issues are fully ventilated. That is the practice in this court.
Yeah.
So very
What?
often we
So
will
what you
have a part
say is
A and part B.
yeah. So what you say is whatever um, the previous judge has given, order that she's given here, and what I'm going to say in this matter, you're going to set the matter down for part B, and then the parties will argue the same issues on the same papers, unless they ask for leave to file additional papers. Do I understand that correctly?
No, my lord. The issues will be fully ventilated in part B. The grounds for withholding the pension. In this
Yeah.
instance, for example, and in most cases, when an urgent application is drafted, it is done so in extreme urgency under extreme time frames, and that the other
Well,
party has not had the opportunity to respond thereto.
yeah,
And
but do you
therefore,
then say is that uh, it is envisaged that you will now file whatever happens here, you will file a supplementary affidavits, and the respondent will have the opportunity to file supplementary answering affidavit as well, and obviously a reply. So you're not going to deal on the same papers, you're going to have further averments made.
that is so, my lord. That is the
Okay.
practice in this court, and it is
Okay.
permissible.
All right. Thank you. I understand that. Mr. Rhodes, I don't think you need to deal with that. It's just a matter of curiosity as to the process that seems to me a bit strange. Anyway, because you're asking for reconsideration, and the papers are basically a full set of papers have been filed now, still it's an issue that I've got to reconsider the previous order. So can you start with your argument,
Yes, Your Lord,
please?
Jesus. Our Lord, I won't be taking the full 60 minutes. As Your Lordship has stated, this is reconsideration in terms of Rule 12.9 of the Tribunal's rules. What we say, my Lord, is that the applicant brought the application on an ex parte basis, that the duty to show the utmost good faith. They contend that all they have to show is that there's a prima facie case. We say that might be the case. We don't take issue with the law on that. But they need to have made out a prima facie case and to have explained the basis of the allegations against my client. What they refer to, my lord, is unauthorized gratification in the sum of 24,584,000 rand. And as we said in the heads of argument, they claim that it was money that were paid into account. She denies it. So we say that they have not made out a prima facie case. Similarly, my lord, as your lordship has asked my learned friend, they undertook in terms of the notice of motion to apply for the interim relief pending the finalization of Part B, which is an action, it's a trial. I disagree with what my learned friend stated to your lordship in the introduction now. So if your lordship has regard to their notice of motion, they undertook within 60 days to proceed by way of trial. If one calculates the days, my lord, it would have been the 14th of December 2022, because the rules say we only take what are known as, and our calculation says that turned 14 December 2022, but they give different time frames at different parts of their papers. At the end of the day, my lord, we're now in January, and they have not instituted such an action as envisaged by Part B of their papers. They also argue, my lord, that there was no prejudice in that our client never approached the second respondent for her pension money, but we say that would have been contemptuous because she was aware of the court order that had been served on her, that she could not post or after the fact approached the second respondent to pay out her pension fund, well knowing that there was a court order against her. So we say it's nonsensical to now say that there's no prejudice simply because you haven't asked for your money when you knew there was a court order that you weren't entitled to do so.
Excuse me, can I just deal with that first
Yes, my
point
lord.
that you've raised? You know, I think we are on the same score, on the same page pertaining to the manner in which the notice of motion was drafted. But if you look at the part A, they refer to the 60 days doesn't come in part A. So what they say is that, and that is the order that was granted, that paragraphs 2.1 and 2.2 shall operate as interim relief pending finalization of part B, not the action. And then there's another part B, which says is that, well, now we're going to ask for confirmation of that orders pending finalization of the action, and that must be instituted within 60 days. So what they say is we're not even at part B, and you guys will get a second bite at the cherry when they come with part B to the court. And obviously then they're going to give notice to you, and we're going to face the same issue, perhaps with amplified at a later stage.
Yes, my lord, we say that's nonsensical. It doesn't make sense. Because the way I understood it, my lord, to try and explain what your lordship had asked my friend is, this would serve as an order pending the finalization of a trial, not the reconsideration, reconsideration of this matter. So it's nonsensical that would be confirmed in part B, and then it'd still be a trial within 60 days, because we've passed that. That horse is bolted already, my lord. So I see it the same way as your lordship does in that regard, with respect. Lord, what we say further is that we say that on the papers, in the answering affidavit, we denied receipt of payment. So we said we never received any payments, and we also denied that there were any secret profits paid to us. That hasn't been dealt with, my lord, by them. They don't deal with that at all. I'll highlight just one or two paragraphs in their heads of argument, my lord, where this is dealt with, and then subsequently in my heads of argument. So starting with theirs, my lord, at paragraph, sorry, to go back on one point for which I apologize, my lord, the issue of no prejudice because we haven't claimed our money. We say that's got no basis, but I don't want to repeat that. But turning to the point in question, my lord, it's from paragraph 37. Beg your pardon. Where they say that they're only asking for temporal relief. I don't know what they mean by that, my lord. They say in 37, the relief sought by the applicant is temporal in nature. Therefore, it is imperative that this approach is the matter. The relief sought will only be in existence if confirmed at this juncture. All the applicant seeks is the maintenance of the status quo. Therefore, it is a holding order that merely preserves the status quo. And we say that that can never be the case, my lord, because they secure something, they say they're going to institute an action, they haven't instituted the action, and then they say that there'll be a confirmation pending the institution of the action. We say that's nonsensical. So we say that that can never be the case, my lord. Another issue, my lord, is in the heads of argument that paragraphs 42 and 43 in the heads. They say that our client, Ms. Moyo, has failed or refused to explain herself to the investigator, and she's failed to place her version. Her version's on record, my lord. It's a denial of the allegations against her, and in particular, she denies any familiar relationship to the persons as alleged. And that's the point that we wish to make. We say that no case has been made out, and this is dealt with in our heads of argument, my lord. And I'll just point to the pertinent points there, my lord. We set it out starting from paragraph 6. We say that she made it clear that she disputed the investigator, Mr. Neve's factual contentions in relation to her. And in particular, she denied that she'd ever received any payment of 24,584,000 Rand. We've given the references with paragraphs. I work the same way as your lordship. I can't work case lines, I admit that. So we do the paragraph referrals. And we also say that she denied that she was related to Lloyd Muzi Sambo when the allegation was made that he was her brother-in-law. And we also pointed out there that in paragraph 7, that no action had been instituted despite the different timelines. And as your lordship pointed out in the part B of the notice of motion that said would be instituted within 60 days. Neves, in his affidavit, says it will be 30 days after the conclusion of this application, which is also expired. And then in his reply, he says at the conclusion of this application that they would do so. So I don't know what time frame they envisage. It defies any possible explanation. So none of the, if you take all three of them, none of them have been met. We say in paragraph 12, as I already highlighted to your lordship, that they proceed on an ex parte basis. They have an obligation to show the utmost good faith and place all material facts before the court. We then say that they have not complied with that. And we set out why we say, firstly, that they haven't made out a case that you had received payments in the sum of 24,584,000 rand. And we say that Neves doesn't deal with that at all. We also, in our paragraph 13.2, my lord, point out that Lloyd's Muzi Sambo, is referred to as Sambo, was identified on 2 occasions as being our client's brother-in-law, by reason of the fact that he was married to our client's sister. Then they identify that person as Nzili Carol Sanderson, as being married to Samba, and we say that that's not the case. And we say that Sanderson, and
I've seen that, Mr. Otis. Can I just ask you? Apparently, well, either it's a bona fide mistake or I don't know, but about this question of the relationship between the Sanderson lady or a sister of Miss Moyo and Mr. Zambu. What I just want to find out from you, it is so. When I started to read the papers, I saw this clear allegation that the monies were paid over the 24 million to Ms. Moyo.
Yes.
And I was looking at that stage, I thought, well, they've got bank statements and indications where money flew from or were channeled from the one account to the other. But in all fairness to the SIU's cases, what they then say is well, you've got to, although they said that, it may be argued that they are contradicting themselves, but then they say is there was this scheme. And then if you look at the scheme and how the 24 million was made up, you find out that about 20 million of that went to this trust, where the 2 children of Ms. Moyo are the trustee or the beneficiaries. And although she's not a trustee there, it apparently, a relative of hers is one of the trustees, and perhaps a friend of hers is the other trustee. And then she doesn't deal with that fully. I would have expected more detail as to what was the contractual relationship between that trust and the initial contractor. Why did the money flow there? And if she didn't know that, then her brother should have told her, and that there should have been an affidavit. So that's a bit of a issue that I felt that she should have explained in detail, which she didn't do. And that you say, but listen, look, here's my bank statement. There's no money. There's no 24 million in the bank statement. Honestly, I accept that. And can you perhaps just deal with that issue?
Absolutely, my lord. As I understand the facts, and I'm going even beyond the papers, a trust had been formed by a brother of hers, not as alleged here, and her children are the beneficiaries of those trusts. She was unaware of it until subsequent to her employment being terminated. She resigned, and then subsequently found out about that. Prior to that, on her version, she was unaware of it. She did not, as your lordship say, file an affidavit by her brother explaining what he had done. But she says that she never received them. And they say there's a convoluted scheme, that's how they refer to it, of all these payments that she orchestrated, but they don't give any detail of it. So she was unable to deal with it. That's why there's that unknown in this whole application, my lord, from both sides. That's why. So what she says, my lord, and then they become even more specific, and you'll see this in my 13.3, my lord, where they say that Eskom suffered a financial loss. She denies it. They also say that she purchased the house for 12.5 million and a motor vehicle for 867,000 rand. She denied that, and they never came back with the details. All they said is that that she was directly involved in the loss incurred by Eskom, but they give no accounting for it. And we say, my lord, and this is the conclusion, that having approached the court on an ex parte basis, they ought to have disclosed exactly what they referred to as being this convoluted scheme, or how they say the money flowed. We also, as your lordship has seen in the papers, requested, or she requested prior to this application, the so-called investigation. They say that they're not prepared to give it, and they say they're unable to even find all the information because of the Poppy Act. So we submit, my lord, that a proper case had not been made out, and that upon reconsideration, this order ought not to be confirmed. And we obviously ask for costs as well, my lord.
Plus costs. Reconsideration not to be order not to be confirmed, and we want costs to be paid.
Yes, your lordship, please.
Thank you, Mr. Oudis.
I have to mute myself, my lord.
You can do that, please, and if I need to speak to you, you'll hear me.
Yes, your lordship, please. Thank you, my lord.
Thank you. Ms. Poswa Leratoli, how do you prefer to be called? I know, is Poswa your maiden name?
Yes, that is right, my lord.
How do the judges or your colleagues refer to you?
Poswa Leratoli, thank you, my lord.
It's so difficult for me to have a double barrel surname, but you need to have it. Okay, please proceed with your argument. You've listened to Mr. Oudis.
Yes, my lord, I think the first thing we should consider, perhaps I should deal with the issue of when the action was going to be instituted. I see that there is a mistake, my lord. There is a discrepancy between the notice of motion and the affidavit. And for that, I apologize. The actual days was 60 days from the issue of the order, and that is how we have calculated it. And according to our calculations, taking into consideration the GP09, we still have a further 5 days to file, within which to file the action papers.
But when do you say, does that 60 days period expire then? You know, if I, bearing in mind the practice that I was involved in all the years, and even and also as a judge, is what you normally do is in your notice of motion, you ask for an order and you get an order that you institute your action within 30 days from finalization of the application. That doesn't mean from the day that you file the application, but when the interim application is eventually heard and an order granted. So it's 30 days from that day.
60 days.
I mean, or 60 days, whatever it is, what the time period, or 90 days, or whatever.
So the 60 days, I will just confirm with my instructing attorney. I'll ask my instructing attorney to give me the exact date when.
But is the 60 days now relevant? Because in your Part A, there's no reference to 60 days, because in Part A, you say this order should be an interim order pending Part B. It's only in Part B that you refer to the 60 days. And we haven't even started with Part B.
It is only in, it is, can you hear me, my lord?
I hear you. There was a bit of a confusion, but I hear you.
Yes, yes. The 60 days is only relevant insofar as we have made an undertaking. Judge Pillay did not include that in the order that she granted. So it is not as if we are in breach of the order that was granted by Judge Pillay, and the order which now the respondents seek to be reconsidered.
Yeah,
what we are in breach of is the undertaking which we had made, and my submission is that should be 60 days, and that's what we have been working on. Was the 60?
Are you referring to the undertaking in the affidavit?
In the affidavit, my lord.
Yeah, but that was not part of the order. The order was
Yes,
is in
indeed.
Part B, and in Part B we haven't. Pillay didn't deal with Part B. She made an order in respect of Part A,
That is so, my lord.
and Part A doesn't refer to dates.
No, it
That's
doesn't, my lord.
that's why I say this seems to me as
Okay, we should.
a strange process that you are adopting here, because now you say, well, you've got Part A. If I reconsider this and I say, well, I'm not going to set aside that order, for example, then you've got to go to Part B. You've got to give notice, and you've got to, the matter will then be dealt with again by another judge, either on the same papers or papers as amplified.
Perhaps my lord, I could rephrase that and then have Part B as part of the actions, the order sought in Part B be the actual action proceedings, my lord.
Oh, well, it's, you say in Part B, I don't know whether I must concern myself too much about that, but you say that the orders granted in paragraphs 2.1 and 2.2, that is now of Part A, should be confirmed, that's in Part B, pending finalization of action procedure to be instituted within 60 days. So at this stage, you're not with Part B already. You're still with Part A. We are considering whether Part A should be reconsidered or that order. So I must say that how strange I find this is it doesn't appear as if Mr. Houder's argument that you are in any event out of time carries any weight at this stage. It's just as if you are going to go on a double barrel approach, which I find very strange. But I've got to look at whether Pillay's order should be reconsidered, yes or no.
That is so, my
And
lord.
that's all that I've got to look at. I can make
That-
all sorts of comments about other issues, but I've got
Yes.
to look at her order.
Yes, my lord. When Judge Pillay, my lord, I'm not too savvy with this. I keep cutting you out somehow, but I would just like to highlight the following. When the order was granted, the following facts were before the judge. Ms. Moyo is employed in middle management by Eskom. She's involved in drafting the proposal for the provision of services by Damugelo. She's further involved in processing the payments and everything to do with the duties of Damugelo at Eskom and the role played by Damugelo.
Yes, I've seen that. I've read the papers. I've seen your
Now-
bits of argument. But the point is that I think what we must just remember is that what she says is she was not the only one. She was part of a panel that dealt with this and had the appointment made. But that doesn't mean that you don't have a case. All that I want to say is we cannot say that she was the only one that negotiated the contract, entered into the contract, and nobody else, and she made the payments and nobody else. That's not so easy as that.
Indeed, my lord, it is not that straightforward, and it is not easy. At this stage of the proceedings, all that the SIU has to prove in terms of POCA, in terms of the Prevention of Corruption Activities Act, in terms of the framework of the legislation that empowers the SIU and dealing with the recovery of funds from and the disgorgement of secret profits is a prima facie case. There can be no doubt that in all this I have demonstrated the link. She is there. Ms. Moyo is the common factor. She is there throughout the whole process, even as the funds go into the account of her minor children. into the account of trusts and close corporations and entities, all linked to her minor children, all named for her children. Simologo and Unaliruna are both named for her minor children. So, my lord, I submit that as far as that is concerned, the prima facie unlawful activities, the prima facie secret profits is plainly shown. Secondly, her denial of the fact that the of the knowledge, she claims she didn't know there were trusts opened. She claims she didn't know in the name of her children by her brother, or that her friend Miss Nzama was engaged in some in also equally opened a trust, and there were beneficiaries and directors in trust named for her children, my lord. In any world, that is just highly implausible that she would not have known. And bear in mind, these are minor children, aged 2 years and 3 years old. Therefore, the money flows, and bear in mind the mischief which the legislation seeks to prevent. It's exactly that. And that is why the scheme, the SIU calls it a scheme, and it says it's convoluted, because the objective is really to hide the end beneficiary. And if that were to be allowed, my lord, it would defeat the whole purpose of the act. If at this stage of the interim interdict, the SIU were required to have information that funds flowed directly into Miss Moyo's account, that definitely would defeat the purpose of the act, because this is how people who are involved in money laundering and all these schemes, that is exactly how they operate. And the wording and the power, the wording in all the legislation is very wide and very broad, precisely to cover such conduct. And as my learned, as my lord explained, the brother, she states in the answering affidavit that her brother said he received funds from Puanda because he had dealings with Puanda. He doesn't explain, there's no affidavit to confirm what those dealings were. There's no confirmatory affidavit. And also, my lord, I might add that before the answering affidavit, there was no version from Miss Moyo at all. She was totally uncooperative. She refused to answer questions. Even in the disciplinary inquiry, she abandoned that. So at the time that this order was granted, my lord, there was nothing. There was virtually no version from Miss Moyo, and it was all her own doing, because attempts were made by Mr. Neve to get information from her, and she was either very cagey or uncooperative. Now, the argument that the respondent made its case in the replying affidavit doesn't hold water either. In the founding affidavit, these points that I've mentioned to you, my lord, are all in the founding affidavit. The reason the applicant had to delve into the position of Miss Moyo in the reply was because she claimed she had attempted to underplay her position and to minimize her position, and therefore it was important. Another very important factor is that Ms. Moyo completed these forms, the non-disclosure forms, and claimed no relation, no conflict of interest that are issued by us Eskom. Now, these non-disclosure forms are very also broadly stated to include any connection to a relation by a supplier, any connection of a relation by a supplier, any direct relation, though similarly very broadly stated, and on each occasion, Ms. Moyo claimed there was no connection. And that, my lord, really is what is egregious, because that amounts to fraudulent misrepresentation. And although at this stage we do not have to prove that she knew or she was aware, but all the facts point to the fact that she should have been aware. The only reasonable inference that can be drawn is that she was aware. There is no other conclusion that one can make. That her brother and her friend obtained her children's birth certificates, for example, in order to register the trustee and in order to register the closed corporation. And why would they choose her children's names? It is just most bizarre. She argues her brother didn't have children. But that is a most bizarre statement. It is far-fetched. There is just no way in which this court can believe that. It is just outlandish. Unless there's anything else my lord would like me to address him on.
No, thank you, ma'am. I think what you want in paragraph 6.69 of your heads of argument, you say that the application for reconsideration should be dismissed with costs and the order dated 28 September 22 be confirmed.
That is so.
Judge Pillay's order.
That is so. That is so.
And then if I'm with you, I leave you with what you intend to do thereafter, because I'm still uncertain as to the intention.
To happen. That is so, my lord. And also, another point I would like. Oh, you said that one. I think that is it, my lord. That is it. Indeed, we ask that the order should not be reconsidered, and that the cost should follow the result.
Yeah, you've mentioned that. That's in your heads of argument, paragraph 629. That's the order that you want. Thank you. Thank you. Can I go back to Mr. Otis then? Mr. Otis, reply from you.
Okay, my lord, I'll be very brief in reply. My lord, we say that the relief sought and obtained is nonsensical for the reasons that your lordship has pointed out, because you ask for interim relief and then you ask for not even reconsideration. You want confirmation of the interim relief pending the trial. We say that it doesn't make any sense. On that reason alone, it ought to be reconsidered and set aside. But dealing specifically with the question that your lordship asked my learned friend, I'd like to refer your lordship to paragraph 16 of Neve's founding affidavit. He explains the purpose of the application as follows. He says, the investigation revealed that Ms. Moyo had engaged in unlawful activities and that she received payments in the sum of 24,584,000. The applicant contends that such activities amounted to unauthorized gratification, defined in poker, and then they say that the reason is that she failed to disclose the secret profits paid to her. That's the case that they sought to make out, my lord. In response to that, Ms. Moyo deals with this, my lord, starting at paragraph 5 of her answering affidavit. She denies the contents of this paragraph 16. And she says there, my lord, and this is what your lordship had asked me and my learned friend, she said, at no point during the subsistence of my employment with Eskom did I receive any payment of 24,584,000 rand. This amount has not been deposited into my banking accounts at any given time during my employment with Eskom. Consequently, I did not receive any profit, as there's never been any collusion between any entity and me as alleged by Neve. Additionally, the bundle that was presented and used by Eskom during my internal disciplinary hearing did not contain any bank statement evidencing any such payments. My lord, she also says at paragraph 14 that she's never received the investigation, so this investigation that they refer to is something beyond her knowledge. So ordinarily, my lord, having approached the court on an ex parte basis, one would expect that the respondent would then explain, or the applicant in this case would explain the investigation. Instead, we have the following from Mr. Neve, my lord. It said,
excuse me, Mr. Rhodes, just I'm a bit lost here.
No
Let's go back to the which paragraph of her answering affidavit are you referring to?
My lord, I referred to paragraphs 5.
It's 5 to 13. Are you? About the investigation.
My lord. And then in response to that, my lord, what Neve says is one would expect that he would say, right, here, the investigation or the report is annexed here too, but instead we have it at his replying affidavit, my lord, paragraph 31. Well, 30, he says he denies the allegations in 5 to 7. And he says the applicant contends that Ms. Moyo received a sum of 24,584,000 rand in secret profits. There is overwhelming evidence which shows that the monies were deposited into bank accounts of entities that were linked to Ms. Moyo, including her minor children whose middle names are Onolereno and Chimilocho. The flow of money from Eskom to Makela and his entity points to collusion. The manner in which her disciplinary charges were framed does not absolve her from further charges of criminal conduct. So he doesn't ever say, here's the report or here's the flow of funds. And your lordship will see in paragraph 46, he also simply denies the allegations. And then he says that in his paragraph 47, technically, Ms. Moyo did not receive any monies directly from Tumakelo. However, minor children beneficiaries of Onolereno, and she benefited from the payments made to Chimilocho and Onolereno by Tumakelo/Puwani. So the point that I'm making, my lord, is the matter does fall for consideration because having been given the opportunity to explain why they say that she received this money, they did not do so. And I don't want to repeat myself, but we say even the relief sought and obtained is nonsensical. It doesn't make sense to have an application for interim relief and then to have that then confirmed at a later stage pending a trial that hasn't been instituted at this stage.
You just mentioned paragraph 14 of the answering affidavit, and that's the one that I didn't catch when I asked. Please repeat that. I've got no problem with the version pertaining to the previous paragraphs. In paragraph 14, she says, having not received any documents or information of the alleged investigation, the contents of this paragraph are not within my knowledge, and as such, I'm not in a position to deny or admit them.
Yes, my lord.
But I believe that you said that Neves did not respond thereto, but he in fact responded to that in paragraph 41. He said, well, it says in it, I deny the contents of this paragraph. And then he says in 42, Ms. Moyo was fully aware of the investigation. As part of the investigation on 4 October 2021, she participated in an interview I conducted on behalf of her with the law firm Bowmans. At the commencement of the interview, asked for a few declarations. She understood the interview. She responded in the affirmative when asked to declare that she understood the purpose of the interview. Then he says, I don't attach a copy of the transcript of the interview, but it's available if the court wants that. So the point that I want to raise is that she, the impression that she created was that it was the first time that she heard about all this when the application was, after the order was granted and she received a copy of the application papers, but apparently Neves did deal with it.
Now, my lord, as I see that there's a contradiction here, because in the founding affidavit, my lord, they said that she failed to cooperate and she didn't provide a version.
Yeah.
So this is, and here they say that she was fully aware, but the point that I'm making, my lord, is at the end of the day, they ought to have provided a copy of that investigational report to the court to substantiate the allegations, and to date they have not done so. That's the point, because even if there was a misunderstanding or there's a contradiction as to whether she cooperated or not, at this stage, when the court was called upon, as in this instance, to reconsider whether that relief, that interim relief, ought to be granted or not, at this stage, the applicant for the relief the SA ought to have taken the court into account and say, here are the allegations, instead of referring to convoluted schemes and flow of funds, etc., etc. The report should have been placed as saying, this is what she did. We still don't know what it's alleged that she did. Started off that she took this 24-odd million rand. Then it wasn't that, it was through trusts. Then she said she was unaware of the trust. So one would expect that, say, here's the flow of funds, this is where it ended up. But to date, they have not provided that information.
They have not provided. And you stick with the request that you've asked me to reconsider?
Yes, my lord.
Of course.
Yes, my lord.
Thank you, Mr. Otis. Ladies and gentlemen, thank you very much for your brief but succinct arguments. I am going to, as I always do, go back and read the papers again, consider your arguments, and if you are so satisfied, what I also do in cases like this where we go in MS Teams is to deliver my judgment electronically. Can I do it to all the parties that have been invited to this meeting, Ms. Bourgeois? Are you satisfied with that?
Yes, I'm satisfied with that, my lord.
Mr. Otis? Thank you, Mr. Otis.
Satisfied, my lord. Yes, my lord.
Thank you. Thank you. We'll then end the meeting. Thanks and enjoy the rest of your day. Thank you.
Thank you, my lord.
Bye.
Thank you, my lord. Bye.